Good morning. I'm Gary DeWaal, and this is Bridging the Week for March 11th through 15th, and today is March 18th, 2019. Last week, J. Christopher Giancarlo promised a workable revised position limits proposal before he left as chairman of the Commodity Futures Trading Commission sometime this summer. Separately, the Securities and Exchange Commission's Division of Investment Management sought comments on how its custody rule applies to crypto assets, while the SEC scheduled a full day of public discussion regarding digital assets at the SEC's headquarters at the end of May. Spring provided an early tease in New York City late last week with very warm temperatures, so I might try to enjoy some longer and warmer days. Let's get started. In a broad-ranging speech delivered at the FIA's annual International Futures Conference in Boca Raton, Florida, J. Christopher Giancarlo, chairman of the Commodity Futures Trading Commission, indicated that prior to leaving the commission this summer, he intended to propose a new workable position limits rule that, among other things, would address anticipatory hedging. He suggested no other contents of a new proposed rule other than, quote, it must be responsive to the public comments and ensure that regulatory barriers do not stand in the way of long-standing hedging practices of American farmers, ranchers, producers, and manufacturers who depend on our markets, end of quote. The CFTC last proposed amendments to its position limit regime in December 2016. Mr. Giancarlo was also optimistic that prior to the end of his tenure as chairman, the Commission will finalize a number of unspecified Project KISS initiatives, as well as propose various new cross-border rules, including to establish a framework for non-U.S. clearinghouses that do not pose a substantial risk to the U.S. financial system to register with the CFTC as a derivatives clearing organization under an alternative, presumably lighter, framework. Separately, on the same day Mr. Giancarlo was delivering his remarks at the FIA conference, Heath Tarbert, the nominee to replace him, testified before the U.S. Senate Committee on Agriculture, Nutrition, and Forestry in Washington, D.C. Mr. Tarbert stressed the importance of empowering the agricultural sector with means, quote, to hedge risk and receive fair prices, end of quote. He noted the transformation of derivatives markets by digital technologies and said the CFTC, quote, must remain committed to promulgating regulations that allow technological innovations to flourish. Mr. Tarbert's nomination must be approved by the Senate Committee and then by the full Senate before he may become the next CFTC chairman. The SEC's Division of Investment Management sought comment on the application of the Commission's custody rule to crypto assets. Pursuant to this rule, Rule 2064-2, under the Investment Advisors Act, investment advisors who have custody of client funds and securities must maintain certain procedural safeguards and hold such funds with a qualified custodian, which includes banks, broker-dealers, and other enumerated entities. Among other things, the division seeks input into challenges faced by investment advisors in complying with the custody rule for digital assets, to what extent, if at all, investment advisors consider crypto assets funds or securities, to what extent are crypto assets currently included in calculating regulatory assets under management, and how can distributed ledger technology be used for evidencing ownership of securities. The division solicited comment through a letter to the Investment Advisor Association. In the letter, the division also solicited views on non-delivery versus payment transactions by investment advisors. The SEC also announced it will host a public forum to address distributed ledger technology and related issues, including initial coin offerings and crypto asset platforms, on May 31st at the SEC's headquarters in Washington, D.C. This event will also be webcast on the SEC's website. And finally, the National Futures Association formally proposed a new rule provision and interpretive notice requiring swap dealers and major swap participants to diligently supervise their employees and agents for their swap business activities. NFA claimed that its proposed requirement is quote-unquote broadly written to allow members to develop supervisory programs particularized to their business activities. Concurrently, NFA also proposed amendments to a general supervisory rule, Rule 2-9, to make clear it applies to all commodity interest activities of future commission merchants, introducing brokers, commodity pool operators, and commodity trading advisors. This embraces the swaps activities of such members as well as their futures activities. NFA also proposed in the interpretive notice that non-U.S. located swap dealers and major swap participants relying on substituted compliance with home jurisdiction requirements instead of CFTC requirements may nonetheless be held liable for failure to supervise under NFA's new proposed rule under quote-unquote appropriate facts and circumstances. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.